with that were the people who were involved in the actual seizure and subsequent storage of the drugs. We are here today on the 19th of June, 6 weeks later, in part, due to General Senona's own application to postpone his testimony, firstly from the 8th of May, up until the 1st of June. He presented himself on the 1st of June. Due to the Commission's own scheduling challenges, he had to be stood down to the 5th of June. Came the 5th of June, we accepted that his legal representative was indisposed, and there was a further extension. So the 6 counts of appearance don't seem to tally with my record. The request that he come only after everybody has testified on the Port Shepstone drug bust presupposes that those witnesses implicate him. And there is no fact that even points to that. He was never intended to be engaged on the matter as an implicated person. The thinking has always been to engage him as head of DPCI KZN, who I assume, perhaps wrongly, at the end of the day would accept that the buck stops with him. So the toing and froing of correspondence has always been to try and clarify this challenge, why General Senona believes that he can only offer his version of the events and the questions posed after everybody has spoken. There are rules, as I read them, and the regulations do not allow for that. And it is in that context that the response eventually to his attorneys was that they need not worry about what others would potentially say. He is required to address himself to the questions posed both in the Regulation 10.6 and the subpoena, to the extent that he is able to do so. Should another witness come forward after he has testified to contradict him, then that is for the Commission to engage with and to determine whose version is acceptable and on what basis. I don't know how other commissioners intend to deal with this, but to the extent that I properly understood, my colleague, Mr. Mpofu, sounds like he wants assurances that there will be no straying outside the subpoena. I don't know what that means, but I can assure him that subpoenas are issued, Regulation 10.6s are issued, and in the course of engagement with the witnesses, there are issues that arise from the question and answer session. And for lack of a better term, I'll call them offshoots. And I don't know if it is the offshoots that he would deem constitute straying outside the subpoena, but that just might be an issue with my, my understanding. Did the General speak to some of these matters at his previous appearance in January 2026? Yes, he did. And we are truly aware of that. However, since his appearance in 2026, the Commission has been placed in possession of significant documents that are relevant to the issue. Other witnesses have testified and too produced documents before the Commission. And as the head of the KZN DPCI, we believe that it is necessary to engage him based on what has since come to light. I don't see that to be a challenge. And it doesn't, as far as I'm concerned, constitute toing and froing. It is assisting this Commission to arrive at a correct factual position as regards matters that fall within its terms of reference. The relevance, we maintain that they are relevant. The rules and the regulations tell us so. At the risk of stating the obvious, amongst other things, what this Commission is mandated to interrogate is whether criminal syndicates, including but not limited to drug cartels, have infiltrated or exerted undue influence over a range of entities, including the SAPS, of which the DPCI is a part. And then to consider the adequacy of current legislation, policies, and institutional arrangements in preventing such infiltration, and then to make recommendations where necessary. I don't understand the contention that where he admits he did not follow prescripts, that is where the issue must die for purposes of the terms of reference for this commission.
The one I had in mind, Ms. Loas 3, which says the role of senior SAPS members in aiding or abetting criminal activity, either through act or omission.
I fully agree, and Commissioner Khumalo, thank you. So the challenge I have is what comes across as a position that says, notwithstanding the wording and the wording of the terms of right, the purpose of the commission, that the head of the institution that was responsible for precisely these drugs cannot be engaged more than once and cannot render assistance to this commission. And if I recall, our rules require that a witness becomes available and answers the questions to the satisfaction of the commission. To the extent that the commissioners remain unsatisfied, I submit that the commissioners are entitled to recall a witness to assist them in determining the correct factual position. I do not believe, as Mr. Mpofu suggests, that this commission is attempting, as he says, to be a surrogate disciplinary process or committee of the police. On the contrary, and particularly on the basis that Commissioner Khumalo highlights, the role of senior officials in SAPS, including KZN, remains a pivotal question before this commission and must be answered. And the only person who can answer precisely those questions are those who are deemed to be senior officials within SAPS. It's not a performance assessment, but there will be interrogation about the knowledge, the application, and approval of conduct by the head of the KZN DPCI of members that resort under his authority. And that engagement must be had to understand, as my learned friend correctly pointed out, whether it was, he says, whether it's incompetence or it's deliberate. To answer that question, we must first understand what the understanding was, the appreciation for applicable prescripts and the like, to enable the commissioners to make a determination as to exactly what transpired. An interesting point was made by Mr. Mpofu, where he states that it is unnecessary to recall the general, particularly where he admits that he didn't follow prescripts. I'm not aware of such an admission. I'm not aware of him so admitting in his first statement, during his first appearance in January, in the supplementary statement, nor in the responses to Regulation 10.6. I see Mr. Mpofu vigorously shaking his head, so I take it that he means I completely misunderstood him. I'll take that this misunderstanding is mine. But I just wanted to clarify that precisely what the prescripts provide for and the extent to which they were complied is a legitimate conversation to have with the general, and that has not to date been had. Thank you, Chair.
Thank you, Ms. Sidlo. Yes, Mr. Mpofu.
Thank you, Chair. Again, I'll endeavor to be brief. Chair, well, it looks like my learned friend, there's a lot of things that she says she doesn't understand, or she's at a loss at sea or whatever. I'll try my best to assist. Chairperson, we are not, this is not some quibbling about technicalities. We understand very well the difference between 10.6 and 3.5. as I was at pains to point out in my address. But, you know, those are just lawyers' things. We are saying that if a person is going to be, if some negative or adverse information is going to be given about me, whether it's under 10.6 or 10.20, doesn't matter. I am entitled to know about that in good time so that I can respond to it. So I don't want to get into legalese here. The issue of the matter is that I think Warrant Officer Sender, Brigadier Newswa, Lieutenant Colonel Jacobs, and somebody called Witness H. To some extent, maybe the word implicate is too strong, but there's nobody who can genuinely deny that adverse statements were made about the general by those persons. And that's all we're asking for. We're saying if there's going to be adverse information, which might not rise to the levels of implication or whatever to a lawyer's mind, but which is adverse to his interest, he is surely entitled to have that information. Now, we asked for that information just as an example. There's a letter dated the 1st of June 2026 from my attorneys, which I'm using this as an example. I was saying I don't want to get into the minutiae, but the response to that letter comes from a Geraldine Berger from this commission. And I'll just read the first paragraph. With reference to your letter dated 1 June 2026, we wish to remind you that your client that all witnesses are called to testify on their knowledge of any fact. It is important to mention and place on record that their knowledge is not dependent on whether others who testify before them implicate them. I mean, surely that can't be true. Your client's statement that was called for through relevant notices cannot in any way be implicated by someone else's version of the truth. This is like an arrogant response, I'm sorry. What
was the nature of the request there?
The request, yes.
On the letter of the 1st of June. Yeah.
Yes, Chair. Again, I won't bore you with the whole letter. I'll just pick up one paragraph, just so that you get the gist.
27.
Paragraph 3, sorry.
It's on page 27.
Yes, 27. Thank you, Commissioner Kumalo. Chair, I'll just read one paragraph. I'm sure everyone will then get the gist here. So it says, we refer to the chairperson's ruling on 1 June and so on and so on. Then the paragraph says, equally, we are also instructed to request the statement of Warrant Officer Carl Sender, who in his testimony of 1 June made certain allegations against Major General Senona. And if I may pause there, that's what we mean when we say made allegations against it. As I say, it may or may not rise to the levels of implication in terms of the technical interpretation. And which allegations our client wishes to respond to. Well, if he wishes to respond to, he wishes to respond to. Nobody can take that away from him. Had our client been aware of Warrant Officer Sender's appearance, our client would have requested for copies of his statement and annexures before being excused by the Commission earlier today. That was the first. Our client was made aware by the media that he was implicated in today's proceedings of the Commission. I'm just reading that paragraph as an example. So it was that kind of request. Then there's another one in the next paragraph about Lieutenant Colonel Duma and so on and so on. And then we got the response that I just read out. And then the rest of that letter of the response does what Ms. Melanie and Ms. Silo is just doing about educating us about Regulation 10.6 and 3.5. So you'll see that the last paragraph, to the extent that he may in time be implicated, he shall be duly served with a 3.5 notice and afforded an opportunity to deal with such implication. Currently, there is a ruling requiring him to file a statement before midnight, and is expected to do so, to abide thereby. I mean, there's a veiled threat there that if he doesn't do so, obviously the consequences would follow. So, Chair, I'm really trying to not to make this into a technical issue about the meaning of 3.5 and 10.6 and the word implicated and so on. And not to be technical, as Ms. Silo is rightfully pointed out. Yeah. If we want to go that route, well, we would be happy to do so. And let me, if I don't make one thing clear, let me make this clear. We do not quibble with widening the scope so as to reach the terms of reference, the issues in the terms of reference. Mr. Lo made a good example of that. I thought I had made that concession a long time ago. But what I was saying is this, maybe it's much more nuanced, that, and that goes to, I think, I almost say General Kumalo, to Commissioner Kumalo's issue as well. Commissioners, if anyone misunderstands me to be saying that the Commission must simply technically just look at the terms of reference and straitjacket themselves to that, that's not what I'm saying. At least two of the commissioners, and Ms. Silo and I, were once in a commission where that was important. Almost every witness was asked about regulation this and regulation that, but it was not an end in itself. It was for the purposes of determining whether whatever the terms of reference of that commission were complied or not. That's really what I'm saying. So let me make a silly example. If we're going to be saying that General Senona was always coming late at work, right? It might be very interesting and dramatic for television that he came late so 1,000 times. Yeah, but the answer is, well, so what? Because that can only be relevant if, as Commissioner Kumalo says, that was in aid of aiding and abetting and all those things that are in the terms of reference. Then it's clearly relevant. But if it, as an end in itself, that is a serial latecomer, well, who cares? That's the issue about marrying those peripheral issues to the terms of reference. That's really, as I say, maybe it's a more nuanced complaint that we're having. But there it is. We just want to place it on the record. We don't need to agree or disagree with the evidence leaders about it. The last point is this. We all know the legalese about implicating yourself and incriminating yourself. I don't want to go there. But, and that's where I make this issue about HR and distinguishing this commission from that. Let me give you a live example. On the 31st of January, 2 days after the last appearance of the general here, he was served with a disciplinary notice by the police. And it said in so many words, you are being suspended because of what you said at the Madlanga Commission. Just as plain as that, it was not even hidden. So it was a direct, so somebody was sitting in some HR office watching the proceedings here and taking notes, and then they say, okay, now you're being charged. Now, I don't want to get into the legalese about incriminating yourself, but that's just a live example. By the way, that suspension lapsed because in 60 days' time, nothing had happened. We all know, again, of the inappropriately named Madlanga unit in the police. Yeah.
Let me on record say in so many ways that I objected strongly to that.
I know, rightfully so.
I immediately engaged the National Commissioner, and he agreed that that was named wrongly.
Rightfully so.
But unfortunately, he was suspended before he could do anything. And
yes.
I later engaged the acting National Commissioner.
No, I appreciate that, Chair. In fact, to be honest...
Even the latest name is still unfortunate because it still has commission in it.
Exactly. But Chair, I accept, just in your defense, Chair, I also became aware of it when you raised the objection. it was a well-timed one, because it could have gotten into the minds of the nation wrongly.
It gives the impression that I'm going around arresting people.
Absolutely, or feeding some unit with information. But be that as it may, Chair, and we accept implicitly that is not the case. But clearly, there are people, whether in the inappropriately named unit or whatever its name is, its new name is, or the HR offices of SAPS, who see their task as it's quite laziness, to be honest, as just sitting there here and watching here and then making notes and then pouncing on people. That might be, shall we call it, an inherent danger in proceedings like this. We accept that. But all we're saying is that we shouldn't be playing into that here, in whatever way. Yeah. I think that's, let me just check my notes, Chair. Yes. The point about the repetitive nature of the questioning is not a feeble point. My learned colleague, Ms. Silo, says, I'm quoting her verbatim, the commission has since been placed into possession, since he was here in January, has since been placed into possession of further information on what has since come to light. In the same breath, she's at a loss as to what we're complaining about. This is what we're complaining about. If the commission has been placed into possession of further information, and that has necessitated for him to be called, then we should be placed in the same possession with the greatest respect. That's this. One doesn't have to be a lawyer to understand that. That all we're saying is that, yes, we accept that some new things might have come to light. They might necessitate him being recalled. But what's wrong with placing us in the same position as the commission in respect of those new things that have since come to light, so that we are in a position to assist you? That can be so difficult to understand. And yeah, I don't want to get into this thing about the backstops with him, quite frankly, doesn't doesn't make the cut. Because it doesn't work like that. We know that he was the head in KZN. But how far do you take this back, proverbial back, you know? Then it means this commission should only have two witnesses, the minister and the national commissioner, or the president, because the buck stops with them. I understand that there's a hierarchy and maybe some other small bucks along the way. But it can't be that simply because I'm overall in charge, then I'm expected to know every little detail about every room in SAPS in the whole country. Surely, that's not what the backstops here means.
On your penultimate point, Mr. Mpofu, about Ms. Silo's submission that the general must respond to questions or testify today because the commission has since been placed in possession of new information. On that, and you then say that it is exactly because of that the general must also be placed in possession of that information. You did give, or rather refer to the one example from the letter. As we sit here now, are you in a position to itemize the information that the general has not been furnished with? I'm asking that so as to see whether engagements between you and Ms. Silo cannot resolve
the issue.
Resolve that issue. Yes.
Chair, yes, we are in such a position, but again, I'm at pains to say that we don't want to to delay
Yes.
the testimony.
All right,
We
all
simply want to qualify so that
Yes.
if we get to a stage where the general, for example, says, I can't answer that because I'm being ambushed or I'm hearing about it for the first time, then at least this background must be taken into account. That's really, but
That's thank you for, that's a very practical
yes,
approach.
it's
Thank
a
you very
practical
much for
approach,
that.
Chair, but it will also assist. Remember, my first qualification was that should it become necessary, we'll itemize these things, because if you do it now, it will just take a long time. That's why I was just giving the highlights.
All right, thank
Chair, let me just make, at the expense of speaking against what I've just said, I'll just give you another practical example. We've been asking for the statement, the commission statement of, Brigadier Nyuswa, just as an example. And we have not been furnished with that. Now, it turns out 2 days ago, I'm sitting at home watching the commission, and at night, I can only watch the repeats here. And as the following question is put to, or not even a question, it's an answer coming from General News. So if I'm not mistaken, it's paragraph 43 of his statement. He says, I was made to understand that General Senona has a problem with this. And one of the commissioners, I'm not sure which one, says, we were made to understand by who? And he says, by the evidence leaders. That is, you'll find that literally the whole nation was watching it. Now, what does that say to me? It says that when Brigadier Nyuswa was being recognized or preparing for his statement, he was told what the version of General Senona will be on that particular point. It's not important for now, whatever the point was. Now, all we're asking is for the same courtesy with respect. That when General Senona was also doing his statement, it would have been very nice that he knew what the contrary versions or whatever it is of whoever it is, to the extent that they were available. We accept that the evidence leaders are not magicians or clairvoyants who would know what someone is going to say in the future, but or sangomas. But to the extent that the information was known, it would have been appropriate, let me put it like that, not just nice. It would have been appropriate, legally speaking, for him to be placed in the same position that the evidence leaders chose to put Brigadier Nyuswa. Just on that point. As I say, the point itself is not important, but it's the principle that I'm addressing. Thank you.
Chair, through you, if I may just address the last point, and I don't want to have it toing and fro.
By the way,
let me give you an opportunity to respond to
Just
that
specifically
one
that
issue.
one.
Let Mr. Mpofu finish.
Yes.
And then I'll give you an opportunity to respond.
I assumed he had finished. I saw his mic go off, so I made certain assumptions.
When he said thank you, I also thought so too.
No, I was just being courteous. I've lost my train of thought now. Yeah. I was saying, Chair, that what we require is to be placed in a position where we can maximally assist this commission. Really, that's really all we're saying. It's all very well if people want to us to come here and then say things and then say, no, I'm hearing about that for the first time, so that we can come again, which is exactly what we want to avoid, for him to come for the 7th time or 6th time or whatever the number is, simply because, as you say, Chair, let's say, for example, I was going to give you this catalogue of things now and give it to Ms. Sill, and it turns out that they were deserved to be given anyway. What will be the result of that? It will be that he must now be given that opportunity, come here again next week or next month and so on. We don't want that, because he doesn't have the means to do that. Every time he comes here, he has to pay lawyers, this is a person who's not a person of means. And but at the same time, he doesn't want to face the risk of being pounced upon by that unit whose name we will not repeat after he has been here. So the risks are real. They're not speculative, as I've indicated with the question of the suspension and so on. Thank you.
Thank you, Mr. Mpofu.
Mr. Mpofu, I think in fairness to Ms. Berger, because of how you've characterized her response, and she doesn't have a right to respond in this platform. I think in fairness to her, this must be placed on record. The context of the letter of the 1st of June from your instructing attorney, what that letter does in the penultimate, in the last paragraph, in fact, in paragraph 4 and 5, in fact, maybe let me first say, the context of the letter is earlier in the day there had been a ruling by the chairperson, as you correctly say, that General Senona should file a statement. Now, this letter from the attorneys in paragraphs 4 and 5 seeks a postponement of the filing of that statement. And that postponement is sought on the basis that other witnesses are still going to testify. There are other statements. I should first see those statements, and I should not testify first before the other witnesses that I want to hear what they're going to say. I need to see in their statements what they say about me. The response of Ms. Berger that you have described in the way that you've characterized in the way that you have is to say that General Senona, there is a ruling, you must abide by that ruling. And you can't get a postponement, basically. You've been given a date. So what you characterize as arrogant is really a restating of the position. And I think it should be seen in that context, and I think it is important that the context should be put out. Yes. That's all I wanted to say about it, that in fairness to her.
Thank you, Commissioner Baloyi.
Yes.
We accept that the intention might have been innocent.
Yes.
I'm simply stating to the Commission how it was received by the General.
Okay.
And there was one, for example, that said, no, you must ignore that subpoena, some subpoena, I think one of the wrong ones. And I thought it's all very well to say that to a person, you must ignore a subpoena, but we all know what the implications are of ignoring a subpoena.
Yeah.
So you can only do that really once you've been told to do so.
Yes.
But
no, I was just dealing with this because I thought it is important in fairness to her.
We accept at face value that maybe it was not meant as, just take a hike or whatever, however it was understood. But that's how we read it. Yes. Because in the end, doesn't matter what the tone or whatever. In the end, we were not given that information. That's really our complaint, not the tone of the letter as such.
And maybe the other thing to say about it, so, the response is a response. This is about the internal workings of the Commission. So when a letter like this comes, it's not Ms. Berger who responds of her own accord and initiative. Something like this comes to the commissioners, that you gave a ruling, we now have this letter. So where she says you are required to comply, it is a communication that comes from the Commission, and I think that should be clear. The second issue, and the second one I mentioned only so that General Senona does not, if he's under that impression, it's clear that he's not targeted as such. This is about statements that he asked for this. He was told about was in what Colonel Nyuswa, I think, Brigadier Nyuswa. Testify any witness. In fact, the practice is statements of witnesses do not go out. We don't even publish them. We don't give to the media. We don't put them on the website until the witness has testified. So insofar as he may have requested statements of witnesses yet to testify, the answers he got are answers that apply generally, which is statements do not go out until a witness is testified. And I say that only to dispel any idea that he alone may be treated unfair. If it is unfair, it's unfair to everybody who's had to testify here.
Yeah, thank you. Chair. Very quickly, again, without any qualification, we accept the assurances about the intentions and the patterns of the commission. We have nothing to say about that. The issue we are raising, the fact that no witness has been given information before doesn't make it right with respect. If it's wrong, it's wrong. Whether it's been done throughout, then so be it. Maybe those witnesses did not make the requests, the repeated requests that we made, or maybe they didn't need the statement. We do.
Mr. Mpofu, the practical and logical point is this, that witnesses often have to confirm when the oath is administered,
yeah,
that this is my statement and that's my signature.
Yeah.
And often they have to correct those statements and say, no. So you can understand how impractical it is before a witness has confirmed that that's his final statement to distribute it.
Fair enough.
Because if a witness then, when they take the stand, they say, well, actually, as happened with Brigadier Nyuswa, I discard
yes,
my previous statements and I'm now relying on the one that I finalized this morning.
yes,
It would have been prejudicial to your client if
absolutely,
the ones that Nyuswa had discarded were the ones given to him. So
yes,
there are practical considerations
yes,
that inform some of these processes.
Yes.
So don't dismiss them as being unworkable. They are there for a reason, these
yes.
processes.
No,
Thank you.
Chair and Commissioners, that's Commissioner Baloi's second point that you've just amplified. And again, we accept that. I'm not dismissing, I don't expect the Commission, I don't want to be in some debate with the Commissioners trying to justify some unjustifiable things here. I'm saying here, I accept that you may not, it's been explained to me now by the two Commissioners, and I accept it, that it might not be a practical thing to do to give somebody a statement prior to their testimony. But I've given you examples where that, what you've just told me, doesn't apply. So where's the statement of sender then, if what the two Commissioners are saying? Because he has already testified, he has already owned his statement. So that explanation doesn't assist me. It might assist with another witness yet to come. But it cannot answer my complaint about witnesses that have already complained, or rather testified. Thank you.
Mr. Law, there was the point you wanted to respond to.
Yes, thank you, Chair. I think to a large extent, Commissioners Baloy and Kumalo have addressed this point, and I wanted to address it for the benefit perhaps of all future witnesses. If one has regard to the very letter that Mr. Mpofu has referenced from General Senona's attorneys at page 27, if one has regard to paragraph 4, his legal representatives state, to the extent that Lieutenant Colonel Duma's testimony may implicate General Senona, it will be prejudicial for their client to file an incomplete statement which is silent on allegations which may be made against him by Colonel Duma. This was drafted prior to Colonel Duma presenting himself before the Commission. Now, the challenge is whether or not his testimony may implicate him, and I think Mr. Mpofu correctly acknowledged that we don't have a crystal ball. What we have at any given time is a statement by a witness. And that is where Rule 3.5 kicks in. If that particular statement already implicates somebody, a Rule 3.5 should go out and setting out the extent of the implication. But whether the statement does not, then the Rule 3.5 notice is not issued. But in the course of testimony, the witness may expand on his statement and in the course of doing so implicate. That is not the original statement that implicated. It is important that anyone who will be called to appear understands that. And the point Commissioner Baloyi made, Brigadier Nyuswa is a brigadier, testified on Wednesday, the 17th. Technically, this 17th of June, by the 1st of June, General Senona's team wanted a copy of his statement. And as the Commissioner points out, the Commission does not release any statement until the witness has confirmed it. So I don't know how we can potentially assess General Senona, but I think it is important to point out that it is not a decision that is necessarily prejudicial to him. It's prejudicial to all. So it cannot be claimed that we are being particularly harsh to General Senona. There is no basis for such conclusion. Thank you, Chair.
Thank you, Mr. Law. I forgot to thank you.
I'm sorry. Yes, I think it would be best to leave it there, Chairperson. We really appreciate the opportunity to place those concerns on the record.
Thank you. What you said when I raised the issue of what outstanding information you still required, I think charted the way forward, in the sense that you said, let's go ahead. So I accept that. Let us start with the testimony. Let's go ahead. If anything arises at whatever point, it should be dealt with at that stage. That is, as and when it does arise.
Thank you, Chair. Just a correction for the record.
Yes.
I understand that the protocol is to refer to people with their titles. So to the extent that I said sender, I meant warrant officer sender. Sometimes I get confused with these ranks, but it was not out of any disrespect.
I also do that from time to time. Correct. I just say officer, for example, sender.
Yeah.
But officers are commissioned officers, not every police.
Thank you, Chair.
Thank you.
Thank you, Chair.
Mr. Law.
We are ready to begin.
Yes.
General Senona, as you have confirmed, you have filed a supplementary statement, and we have confirmed it is yours. It goes up to page 11, and it is, as is practice in the Commission, any new statement that is filed, the witness is afforded an opportunity to speak to the contents thereof, either by reading the statement or highlighting certain aspects within the statement and paraphrasing without undue interruption. And I would like to give you this opportunity perhaps to do so. Which parts you choose to read and which you choose to summarize will be at your discretion. Thank you.
Thank you.
Yes, General.
Thank you, Commissioners. I, under design Lesetja Senona, do hereby make an oath and say that I'm a Major General in the South African Police Service. I'm currently employed as the provincial head of the Directorate for Priority Crime Investigation in KwaZulu-Natal. I must also emphasize that although I'm still employed with the DPCI, I'm currently placed on suspension. And the suspension talks to the issues of, in the suspension letter, they say because of the storage and the theft of exhibits, which emanated from the Commission, as my senior counsellor has alluded to earlier before the Commissioners.
Did the suspension not lapse, or did I misunderstand?
Commissioner, if you allow me,
yes.
What happened after I've testified here, I was taken out of my office at gunpoint and on the 31st of January. I raised the issues of safety, but a ruling was done. I was taken out of my office. escorted with firearms, and I was told not to come back to the office. My tools of trades were taken. Although it's not in my statement, I'm just bringing that under your attention that sometimes we come and testify here when we request for safety, what is it that we are facing? And ever since that day, I am not 100% well in terms of safety, my safety and that of my family. And the suspension
Sorry, General. I just want clarity on whether the suspension has not since lapsed.
I think Commissioner.
even Mr. Mpofu touched on that and said because nothing happened over the specified period of time, it lapsed. Now you're saying you're under suspension.
Yes,
it's because of that I wanted to get clarity on whether it has lapsed. It has since lapsed.
Commissioner, it's two suspensions.
Oh, okay.
The first one I was provided with, I was suspended, and because evidence was given at the commission under oath. When you are suspended in the police, within 60 calendar days, a disciplinary hearing must have commenced. And then on the 22nd of May, it was 77 days after I was suspended, the suspension was uplifted, of which it was uplifted by my supervisor, who didn't have the powers to do so because the regulation talks about the chairperson, who must either uplift or extend it by 30 days. If the disciplinary hearing is not finalized, it must be an automatic upliftment. On the 3rd, after I've appeared here, on the 3rd of June, I was called I went to the office here in Pretoria, met with my supervisor. I was provided with another suspension. The second suspension that I'm on now talks to the issues of theft and storage of drugs at Port Shepstone.
Oh, thank you.
And today, I must bring
continue.
I must bring it under the commission attention that I'm more than willing to assist this commission. I am here, but the date the commission gave me, already there was a date for me to attend another disciplinary hearing today at 10 o'clock. It's currently ongoing. To show that I'm willing to assist the commission, I opted to come here, not to go that side. Thanks, Commissioner.
That answers me. Thank you, General.
Can I continue, Commissioner? I have previously filed statements with the Commission and testified at the Commission on the 27th, 28th, and 21 January 2026. I filed this further statement at the direction of the Commission in terms of the summonses of 29 April 2026, and I'm duly authorized to dispose this statement. The facts set out in this statement are within my personal knowledge unless otherwise stated or indicated by the context alternatively. Obtained through reports made to me in the course of my duties by the various functionaries within the DPCI-KZN. Further, alternatively, to the extent possible or feasible, I will attach any documents I rely on in substantiation of the averments I make here in this statement. This statement is filed in response to the Regulation 10.6 notice of 24 May. In that notice, the Commission called upon me to answer certain questions relating to the seizure of 541 kilograms of drugs, in brackets, cocaine. I want to add the word suspected cocaine. At the CHC depot, 14th CHC depot, the Avenue East, 14th Avenue East, Isipingo, Prospect, Devon Harbour, on the 22nd of June 2021, which was booked at Isipingo under reference number SAP 13/373/2021. The Regulation 10.6 notice issued pursuant to the subpoena of 29 April directs that I comprehensively address the seizure of 541 kilograms of drugs in brackets is cocaine. I want to also add suspected cocaine. At the CHT Depot 14th, the Avenue, East Isipingo, Prospect, Devon Harbour on the 22nd. I have attached my answers to the regulation 10.6 SLS1. It forms part of my sworn statement. In the body of this sworn statement, however, I address certain challenges on the management of my evidence at the Commission. Issues concerning the management of my evidence. I think some of these issues, it will be a repetition. My senior counsel has addressed the Commission in respect of that. On the 29th of April 2026, the Commission issued a summons calling me to tender certain evidence, notably that summons did not raise any new issues. I communicated as much to the Commission through my attorneys of record on the 4th of May, when I also requested that in the event that there are additional documents and or information the Commission intends to make use of during General Senona's further appearance, we request that he be furnished with information, in brackets, documentary and or otherwise, close bracket, timelessly to enable adequate preparation. A copy of this correspondence is attached as LS2. The request has not been met. At least 3 witnesses have given evidence implicating me in the drug seizure and storage of 22 June 2021. A 4th is set to tender evidence via audio link and in camera. The first of these witnesses to testify was Major General Flynn. His statement was filed on the 4th of May 2026, and he gave evidence at the Commission on the 5th and 6th May 2026. The second witness was retired Lieutenant Colonel Prinsloo. To date, the date of his redacted, so I do not know when his statement was filed with the Commission. So which means the date he disposed this statement, I'm not aware of it. In any event, he testified on the 7th, 11th, and 18th May 2026. The Commission only furnished me with their statements late afternoon on Friday, 29 May 2026, a mere 2 days before my own statement had to be filed with the Commission on the 1st June 2026. It's more, I was also called upon by the summonses of the 29 April 2026 to testify on the 8th of May 2026, and then postponed to 1 June, although I was advised that my testimony may stand down to the 5th of June 2026. As an aside, I have several concerns regarding my evidence tendered by Colonel Prinsloo. These include his failure to disclose to the Commission that he informed the District Commissioner in that district about the storage of the drugs, and that he requested visible policing patrols in the area. He alleges that I instructed that no one be informed about the storage, but he never requested additional assistance from my office.
Sorry, General Senona, just to be clear, you're still referring to the suspected cocaine, not another storage?
100%, Commissioner. Apologies for my oversight. I think it will happen oftenly, but I apologize upfront if it is allowed, Commissioner. Thank you. Where was I? I instructed that no one be informed about the storage, but he never requested any additional assistance from my office. Reference is made to paragraph 7 of his statement, of his affidavit, disposed to shortly after the incident. I'm not sure if that statement is here, Commissioners. I want to check so that I can read the paragraph, but it is not here, but we submitted it previously in January.
If I may be of assistance, that is what we're trying to establish. There are actually 2 statements by Colonel Prinsloo. There is one, you said immediately after the incident. There is one of the 23rd of November 2021, and another of, I think, the 25th of November 2021. And I mention this perhaps just to ask your attorneys or your representatives to guide us specifically which statement they're referring to, and we'll be able to locate it, and then you can have regard there too.
Is a statement that he made immediately after the incident where we were requested by Lieutenant General Musikidi to provide affidavit of the incidents.
Hence, I say there are 2 days apart. The one is the 23rd of November, the other one is the 25th of November.
If it's presented before me, because it's a long time ago, I'll be able to say this is the one. I think in January, we did talk to the statement. It was handed in before the commission. I'm referring to that one that we were dealing with in January.
I think Advocate Talk might be able to assist. In the meantime, if it doesn't disturb your flow, you may continue while we try and locate the actual statement you are referring to.
Thank you very much, Commissioners. Lieutenant Colonel Prislow also failed to disclose the visit to me by Brigadier Naika, who is from head office, and the 2 warrant officers at Port Shepstone offices. Commissioners, my office never received any report or feedback concerning such visit or inspections. Reference is made to paragraph 10 of Lieutenant Colonel Prislow's statement that he deposited immediately after the incident. I'm saying this, Commissioners, because when head office visit any of the provincial offices, the protocol will be that you report at the provincial office your presence, and then in that I'm visiting this office. If it is investigation of a sensitive nature, you just report your presence and you go do your investigation. And I have never received any report from national office or any document in respect of such a visit, as well as the outcome of the inspections that was conducted there. He indicated that he could not...
General?
Yes,
is the point, I'm trying to understand the point you're making here at 12.2. Is it that you dispute that there was such a visit that he speaks to in paragraph 10, as you say, in paragraph 10 of that affidavit? Or you say you accept there was such a visit, but the only issue you're taking is it was never disclosed to you? I'm trying to understand that I don't lose the significance of why you're saying
Yes,
this.
Commissioner, you are 100% correct. I'm not disputing the visit.
Yes.
However, I'm indicating to the commissioners, although I didn't put it here, that the visit initially was never brought to my attention. And thereafter, even a report of such an inspection was never brought or sent to my office.
Okay, thank you.
Thank you, Commissioner. He indicated that he could not smell anything suspicious, despite another member allegedly observing a burning smell. Although he testified about the security concerns and challenges at the offices, he failed to escalate these concerns directly to my attention after his alleged unsuccessful attempts with supply chain management. At no stage were the security concerns at Port Shepstone brought to my I think I also testified to that effect in 27 until the 29th. I did highlight these, Commissioners. He also failed to complete the relevant document to the handing over and control of the safe keys, despite him being aware of the applicable procedures. These procedures were not within my knowledge, and I've never dealt with the same before, even in relation to the safe in my office. Commissioners, here I'm saying I am not an expert in the supply chain management issues. There was a document that was presented before this commission by Lieutenant Colonel Prinslow, the handing over of the safe keys and so forth. It was the first time I saw it. I won't know everything in the South African police services. When the keys were handed over, I would have expected him to say, let me complete this relevant document in order for you to sign. And
Are you, sorry to interrupt you, General. Are you talking about the instance where the keys were handed over to you after the suspected contain had been placed inside this strong room, or whatever it's called?
Correct,
All
Commissioner.
right, thank you.
Unless, because he never testified that I tried to complete that and hand, so that they must sign for the keys or so. It never happened, and he never testified in that instances. Although I'm saying before this commission, that document, I saw it for the first time before the commission. I won't know everything in the police. Commissioners, he failed to properly inspect the office premises during the afternoon of the Sunday on the 7th of November 2021 and the morning of Monday, 8th November 2021, despite observing that lights were on at the ground floor, which he considered abnormal. No occurrence book entries were made in this regard. All I'm trying to highlight here, Commissioners, I testified previously that they were instructed to do the after-hour visit. And I consider this visit of Sunday as one of the after-hour visit, as per my instruction after the storage. But if you do that, you must go and patrol the entire office and check if everything is still intact. What is significant, he knew what was stored there, but he never went down. In his testimony, he said he only went into his office and did what he did, and from there he left, of which it leaves a vacuum in my mind why he never did that. He further failed to disclose the visit by Brigadier Nyusa to the Port Shepstone offices on Tuesday, the 2nd of November 2021, shortly before the theft occurred. I can confirm, Commissioners, that Brigadier Nyusa also testified here, and he confirmed that he did visit the office on the 2nd of November 2021. But from where I'm sitting, I've never visited that office ever since those drugs were stored at Port Shepstone. In any event, I appeared before the Commission on the 1st June 2026, and my evidence was stood down to 5 June 2026. In the meantime, while I was preparing this statement and consulting on the 29 April summonses, the 24 May Regulation 10.6 notice, and the statements of Messrs. I will say General Flynn and Lieutenant Colonel Prinsloo, the Commission led the evidence of Warrant Officer Carl Sanders and also ruled that Lieutenant Colonel Dumas' evidence, which also relates to the theft of the cocaine, could be led via audio link while shielding his identity from the public. At this point, my attorneys wrote to the Commission requesting that my evidence be stood down and my statement filed at a later date after all the evidence implicating me was laid. In this way, I could provide a complete answer to the Commission, which necessarily include answering any allegations made against me in the seizure of the drugs and their storage. The letter is attached as LS3. The Commission responded via emails contending that I was only required to respond to the issues in the subpoena and the Regulation 10.6. The Commission's Ms. Geraldine Berger stated that is what constitutes his testimony to the Commission, and that if all that is required of, and that is all that is required of him now. She goes on to state that I will be served with a Regulation 3.5 notice and afforded an opportunity to deal with my implication, but records that my statement is not impacted by someone else's version of the truth. The email is attached as LS4. Her opinion was in the end proven wrong when Warrant Officer Sander took the stand again on 2 June 2026. Insofar as Warrant Officer Sanders is concerned, he was questioned by Commissioner Khumalo on his temporary placement letter that was signed by me. Commissioner Khumalo noted that I am coming to give evidence on the 5th of June 2026, and Commissioner Khumalo stated that the allegation you made is very serious and it goes to the heart of the terms of reference of the Commission.